doesn't like the document?
No.
Okay. Do you want me to go save it again on the flash drive?
Yeah, because it opened this PowerPoint, but it's saying there's an issue with this.
Okay, I've got another flash drive. I'll be right back. I'll be right back. If you don't mind, if you can like, just leave my block, because I'll do the email. Something that would make you happy as an alternative. Your Honor, I apologize. I have to go
I
back
heard.
to the office. Also, if Ray Webb's not here, then certainly Attorney Pickens gets to go first.
Sure, no problem. All right, when you get back, we'll start. All right. Right now, there's tens of people wondering why we're not on the air.
Yeah. Just sitting there staring. We all decided to wear blue today.
Okay, great. All right, good morning, everyone. This is the City of Daytona Beach Shores Code Enforcement hearing for September. I'm Stephen DeLaRoche, the Special Magistrate for Code Enforcement. The way we conduct our meetings here is the city has the burden of proof. They get to go first. Then you have an opportunity to ask them questions. Then it is your turn to present whatever case you would like, and then I'll make my ruling. If at any time you do not understand what is going on, please ask, and I'm more than happy to tell you. I'm not going to go into a lot of detail because I have an attorney here as the only person in the audience, and I have a reasonable belief that you understand how these things are conducted. Okay, first order of business as always is approval of the minutes. Anybody have any good reason why the minutes should not be approved? Okay, hearing none, the minutes are approved. The first case we have is Halifax Investment Services, case number CDEF 2023-24. And sir, you represent them?
Yes, Your Honor. I represent Halifax Investment Services.
And what's your name?
My name is James Pickens.
James Pickens?
Yes, Your Honor.
Okay. All right. If you have a choice, you can stand there, you can sit in the first row. Ms. Herstein goes first, and then I'll let you do whatever you would like, unless you two have some sort of agreement that's been worked out.
I do have one request, Your Honor, because I don't want to waste the court's
Sure.
or code enforcement's time. I wanted to request a continuance. I was unable to secure the appearance of our expert witness, our engineer. I believe his testimony would be critical for the court's consideration in this matter, especially when the primary issue involves a seawall.
Okay. Is the engineer Charles Adams?
Yes.
Okay. And I did read his report. Ms. Herstein, do you have an opinion?
The city, I would like to introduce the documents into the record if we're going to discuss it further, and I can do that. Actually, why don't you answer this question and then we can go from there and I can introduce the documents. The city is not in favor of a continuance at this time. We have offered and expressed that our position is that just over 7 months be given to become compliant, including building the seawall, backfilling, and getting the engineer's approval.
Okay.
Because by April 30th, and that is the day before the next turtle season starts. I have been given, and our office has been given no indication that next turtle season will be under the same rules that this turtle season was. We hope that would be wonderful, but at some point we're going to be told no. And it has been a year since almost a year since this damage occurred. Our position is that we ask you not to grant a continuance, that we move forward with that 7 months in mind because of the nature of turtle season. If we come back in a month, then we're talking 6 months, and it's a less reasonable time to get the things that we hope to get done.
Okay. I understand where the city's coming from. Let me ask you this. Are you going to rebuild this thing or are you going to demolish it?
Well, that is the key issue, Your Honor. We're dealing with a seawall here. We have adjoining properties to the north and south who also have compromised seawalls.
Okay.
The thinking is, and the testimony I would proffer from our expert would be repairing our seawall without the adjacent property owners in collaboration would be a monumental waste of money because our new seawall, hundreds of thousands of dollars in investment, would be washed out.
Right, the water will go around and behind, I get that.
Exactly, and the east building that has been severely undermined, if we can't get the seawall replaced, that building would likely be demolished, and another one of the violations is the roof on the east building. Why would we repair a roof on a building that's going to be...
You're going to knock down, I fully get that.
I do have a response to that.
Sure.
And I would like to ask that each of the documents included in this PowerPoint file, whether presented during the hearing or not, by the city for this case be accepted as evidence, most of which have been provided to the special magistrate, all of which have been provided to the respondent's representative.
Okay. Mr. Pickens, do you have a legal objection to anything that the city intends to introduce?
No, Your Honor.
Okay.
Other properties, if I may, other properties have had to deal with this issue where the neighbors were not ready yet, and they were ready to move forward, and they've had to build that into their approach to rectifying the seawall, whether it's a return wall, whether it's, working something out with the neighbors. Others have been in this situation and have been able to move forward.
Okay, and I understand that. Mr. Pickens, this is the predicament I'm in. The turtle law is like the Americans with Disability Act. There's nothing that comes in front of it. It overrides anything that I can do as far as a code enforcement magistrate. So if I give you the continuance and I do find the code violations, the city requesting that everything be completed the day before turtle season, I'm not able to adjust that. So if you'd like your continuance, you're going to lose a month to rectify any violations, if there are any.
That being said, Your Honor, then I think it would be no harm, no foul if it doesn't change the deadline.
Okay.
To grant the continuance so I can have the competent testimony introduced into the record.
Okay, and I understand the city's position. I have read the report of the engineer, but, of course I'd like to hear from him. I'm going to grant you the continuance. Yes?
I would like to say one more thing. I'm sorry, Your Honor, but if this is the way that we're going to go, and then we're going to be in a period of possibly around 6 months to rectify, the city will also be asking at that time for temporary armoring to take place, which will be at increased cost to the property owner, but we think is necessary for this particular situation.
Oh, I fully understand. I fully understand.
Specific temporary armoring. We'll have a suggestion, and
That's why I'm giving Mr. Pickens a choice with
Thank you,
the
Honor.
ramifications of his choice being known to him. I'm trying to make it fair for both parties. This is your second continuance. I've never given a second one. There won't be a third.
I understand, Your Honor. Thank you.
Okay? And, all right, so we'll see you back here next month. And there is no November code enforcement hearing. So there absolutely will not be another continuance.
Understood.
Okay? All right. And Ms. Herstein, I understand your concerns, but they've been warned that if I do find a violation, it's going to shorten the period. And then if you exceed the period, it gets really expensive. It's $250 a day. Okay? I understand. I've stood there before. All right, you can stick around for this very exciting session where I don't have anybody on the other side, or you're free to leave.
May I be dismissed?
Yes, you may. Thank you.
thank you, Your Honor. Thank you.
All right. And I understand. I don't like to grant continuances when they've had one previously, but
I understand too. I'll stop right there.
okay. The next one is case SCDEF 2023-13. Why does this one have a different case citation than we're used to? Why is there an S in front of it?
That is for my benefit when I'm looking for, I have different types of cases in different areas. If I'm working on a group of similar cases, signs, seawall, backflow prevention devices, and permits, I keep them in different places because they're related and they have.
So S stands for sign?
In this case, it stands for sign, but in the others, it can stand for seawall.
Oh,
So,
okay.
but I didn't switch over for, anyway, yeah. It's all,
As long as you know what you're doing, that's fine. It caught my eye.
thank you for assuming that I know what I'm doing.
All right. This is another sign case. Is there a representative present for Pinchas Maine?
Pinchas Maman.
Oh, thank you. I guess not. All right. Would you mind raising your right hand and being sworn? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. I've had an opportunity to examine the materials you gave me. I've seen the pictures. If you'd like to proceed.
Thank you, Your Honor. I'll make it brief. Initial hearing, this is initial hearing for a notice of violation issued May 3rd after the 11 years to become compliant period ended in April of this year.
I said that out loud when I read this. I'm like, 11 years?
Notice of violation starts, you can see it starting on page 5B5. Good service was achieved for that notice of violation, and you can see the support for that good service starting on 5B8.
Right, I also saw the picture where you posted next to the sign.
Absolutely. And I do have an affidavit supporting that as well. I did hear from Ray Webb. He is with principal at Kenco Signs. He let me know possibly they did get that service, but it didn't. He was looped in at that point.
Okay.
Okay. He let me know that he'd already had a proposal for Mr. Vermon. Mr. Vermon hadn't signed it, but he thought maybe with the notice of violation going out, it would maybe move things along. So I gave him an opportunity to work that out. Unfortunately, that didn't happen. And so on August 3rd and 4th, looking back at that notice of violation and the service being imperfected at that time, I did, out of an abundance of caution, post it, the notice of violation again, August 3rd and 4th.
Okay.
So resent it certified. I do believe they received it, but I didn't have any way to concretely demonstrate that it was perfected. I did have good service at that point, and that's what you're going to see on 5B8.
Okay.
I re-inspected in early September, September 8th, and I mailed and posted the statement and violation request for hearing for today's meeting. You can see those documents starting on 5B13, and there is support for good service being achieved for those notices on 5B19. I would like to show you pictures, a brief picture of the violation, along with reading the violation, and then I have a recommendation.
Okay. I do have a question that when I looked at these, on the left in the yellow box, that sign is the same one that you see on the right, is that correct?
It is the same frame. The faces were different. Hurricane Ian came through and knocked the faces out, which you can see that picture was taken October 12th, 2022. Unfortunately, and I believe it was Mr. Webb, but we don't have a permit for it, so I can't be sure. A sign company went in and put new faces in without a permit. So we didn't have the opportunity, which we would have if a permit like that had come in, to say,
Right.
maybe don't spend your money in this way, because in 6 months' time, it's absolutely, that has to be gone, moved, changed completely, not just
Okay.
moved.
That's what I had wondered about, why they were allowed to replace the face
They weren't.
on a sign that was clearly outdated according to the code. Okay, that answers my question.
But at
Thank you.
that point, to send them a notice for doing this work without a permit, it would have just been like insult added to injury when I knew this would ultimately have to go out.
I get that.
Thank you. Okay, so the top left picture was the one you just saw. That was the initial inspection back in April. That's with the new sign faces put in. And the two bottom pictures were taken September 8th. One is the north face. The one on the right is seeing it from the south approach. Same faces. They appear the same.
And are there two businesses occupying this?
There are three, actually. There is Foxy Locks, I do believe that they're still there, Quick Stop Food, and then the Go Juice. And Foxy Locks would be all the way to the, just out of the picture frame on the left at the bottom right picture.
Okay. And does the structure have one owner?
The structure has one owner, Mr.
Okay.
Vermon.
And the other, all right, I get that.
Mr. Vermon does own other properties in the city, which, so he's familiar with a lot of our regulations, which is why I really thought that this would move forward on its own without having to bring it to a hearing. Okay, I did want to tell you the violation A reads Quick Stop Food, Go Juice. The non-conforming sign remains in place beyond the 10-year period allowed by this section and the 1-year extension granted by resolution. And I wanted to further describe the existing sign is non-conforming in a variety of ways. Number one, it does not meet the definition and parameters of a monument-style sign. 3 different parts of that monument-style sign ordinance. The Land Development Code, Section 6-8.6.1, A, B, and D. And I have them here if you do want to look at them, but it's not necessary we go that far, but I know it's important that I demonstrate to you how it's not conforming.
Well, this is our 50th sign case. I've reviewed the ordinance. I know what it should look like, so I'm fine with it.
In another situation, though, I think we'll say number 1, but the second one down is number 2, please, Your Honor. The second bullet is that the sign is actually closer than 2 feet to the sidewalk, the right-of-way sidewalk, and that's not allowed according to another ordinance, or another part of this same Land Development Code chapter.
Okay.
That's going to be an issue. Further beyond that, the city planner, when speaking about this sign, saw that it may not even be on the property, which is a whole other issue. It may be a foot or so, or maybe more, south of the property line.
Right, but that's not a code problem.
It is when it comes to, could they use the original foundation? Could they do this and that? It adds a complication in that they are going to have to get a perimeter survey or locate a recent perimeter survey to demonstrate that. We have seen that in one other case regarding these non-conforming signs, and it turned out, based on the survey that was provided by the property owner, to be on the property that just hadn't matched up exactly with the property appraiser's records. And that's understandable, and that's why we ask for a survey in that situation, because it could happen. It doesn't happen often. So in light of that, and it not being, normally we especially if somebody is not here or we know that it's pretty run-of-the-mill, we would ask for 60 days. In this case, because they may have other pieces that have to be addressed, we're going to ask for 90 days. So we're requesting an order number 7, that you find the property in violation, that you ask that you order the violation corrected on or before December 20th, 2023, which is 90 days, including obtaining approved final inspections on all required permits, that the respondent pay an administrative fee of $149.09, and there's an affidavit supporting that on 5B25, or fines of $150 per day will be imposed. And it is known for this property and others that simply taking down the sign is a means to become compliant. They don't have to have the new sign up. However, based on multiple conversations with the business owners there, at least 2 of them, not having that sign could potentially put them out of business, and the city is very sensitive to that. And so we're hoping that they can do that within the 90 days, leave this one up as long as they need to, but then have a time certain by which they have to have the new one, in place, or they can take it down in 90 days.
Okay.
Oh.
Seeing no what?
I would like to ask.
You're going to ask Steve to testify?
No, Your Honor. I'd like to ask that each of the documents included in this PowerPoint file, whether presented during the hearing or not by the city for this case, be accepted as evidence, most of which have been provided to the special magistrate, and all of which have been are available to the respondent and or their rep, most of which have been already provided to the respondent by the means identified in this packet. And I apologize that the building official has a cough.
That's okay. That's all right. Hearing no objection, they're accepted into evidence. The city has met its burden. I'm going to issue an order number 7, finding the single violation A, and asking that it be, or ordering that it be rectified within 90 days, December 20th, 2023. That in the event that they do not rectify the problem, $150 per day as a fine will attach, $149.09 for administrative fees to be paid within 30 days by the respondent.
Thank you. And they do have to obtain approved final inspections on all required permits? Of
course.
Thank you, Your Honor.
That's the rule.
Yes.
I don't have to order that. That's just the rule,
Thank you, Your Honor.
right?
I always feel more comfortable when you say it.
Okay, yes, they have to get final inspection and all necessary permits signed off on. All right. Well, this went much quicker than I anticipated. Any other business? We can talk about the drone stuff off the record if you still want me to talk about that. And next meeting is October 19th at 9 a.m. And that concludes this